Welcome to the Explainer. Ever wondered what happens when you take a job with a foreign company, or even just click I agree on an app from another country? Well, there's a hidden legal puzzle in those agreements that decides everything, and it all comes down to one big question. When a contract crosses borders, which country's laws actually apply?
Okay, let's just dive right into this with a real-world scenario. Imagine this. You're hired in the Philippines to work for an airline based in Pakistan. Your contract clearly states that Pakistani law is the one that applies. So, is that enforceable? Can they actually do that? This isn't just a hypothetical, you know? It's the very heart of a huge legal field called conflict of laws. And trust me, the answer might surprise you.
So anytime you have a contract that's connected to multiple countries, you get this puzzle. If a fight breaks out and there's a dispute, which country's legal rule book do you even open?
At its core, a contract is pretty simple, right? It's basically just a set of rules that you and another party agree to follow. In a very real way, those terms and conditions become the law between you.
So that leads to the crucial question. Can you just choose the rule book you want to play by, right from the very beginning?
And the law generally says, yes, you absolutely can. This power has a name. It's called party autonomy, and it's pretty much the starting point for almost all international contracts. It gives both sides the freedom to pick which country's legal system is going to apply to their deal. But, and this is a really big but, this freedom isn't a blank check. The choice you make can't go against a country's fundamental values. We're talking about things like public order, or the really important one, public policy. Think of it like a legal safety net, making sure contracts don't violate a nation's core principles.
For example, there was this case with a Filipino seaman named Pancho. His contract said Hong Kong law would apply for his benefits. The Philippine court took a look and said, yeah, that's perfectly fine. So if that one was okay, when does a choice like this cross the line?
And that brings us right back to our opening question about the airline. This is where we see a dramatic showdown in court, a case that really put the limits of party autonomy to the test.
So this all comes from a landmark case involving Pakistan International Airlines. The airline hired 2 flight attendants in Manila, and their contracts were crystal clear. They had a fixed term of 3 years, and they were going to be governed by the laws of Pakistan.
But here's the catch. There was a clause in that contract, and it was totally valid under Pakistani law, that allowed the airline to fire them for literally any reason with just 1 month's notice. Now this flies directly in the face of Philippine labor law, which has incredibly strong protections for job security.
And that's exactly where the court drew the line. They ruled that, in this case, the choice of Pakistani law was invalid. Why? Because protecting workers isn't just some regular law in the Philippines, it's a fundamental public policy. And you simply cannot sign that right away in a private contract.
And this comparison just illustrates the whole point perfectly. In the Siemens case, choosing Hong Kong law didn't step on any of the Philippines' core values. But in the airline case, picking Pakistani law was an attempt to strip away a fundamental, constitutionally protected right, and that is the line in the sand.
Okay, so what happens if the contract doesn't say anything? What if the parties just never chose a law to begin with? Well, the courts have a backup plan for that.
Yeah, when a contract is silent, the court has to become a bit of a detective. It has this legal toolbox it can use to figure out which country's law makes the most sense. They'll look at where the deal was made or where the work is supposed to get done, or sometimes they'll take a much broader view to find the place with the deepest connection to the whole thing.
The most traditional tool in a box is simple. You just use the law of the place where the contract was physically signed. For a really long time, this was the go-to rule because it's predictable. It's easy. You sign a contract in Paris, you get French law. Done.
But what if you sign a contract in one country, but all the work actually happens in another? That brings us to the second approach, which focuses on the place of performance. The thinking here is that the law should come from the place where the contract's main purpose is actually being carried out. Kind of makes sense, right?
And finally, we have the most modern and flexible tool in the toolbox. It's called the most significant relationship test. Courts realize that in today's globalized world, contracts are complex, so instead of looking at just one single factor, they now weigh everything to see which country has the strongest, most genuine connection to the agreement and everyone involved. Now, this isn't just a judge going with a gut feeling. To figure this out, they use a specific checklist. They look at all sorts of things, like where the negotiations happened, where the parties are from, and where the performance will actually take place, all to pinpoint the contract's true center of gravity.
Now, this might all seem like a really technical topic, something for international lawyers to worry about. But this whole idea of choice of law actually affects you almost every single day. Think about it. That giant wall of text you scroll past to use a new app or sign up for some online service, I promise you, buried deep inside those terms and conditions, there's almost always a choice of law clause. It says you agree to be governed by the laws of California or Ireland or some other place you may have never even been to.
So remember, your signature on a job offer, or even just your click on an accept button, it's a powerful legal act. And it leaves us with one final thought. In our borderless digital world, do you really know whose rulebook you're playing by?